As a civil law notary, I can provide information on a specific Hague Convention that deals with trust. One such convention is the Hague Convention on the Law applicable to trusts and on their recognition. The Hague Convention on the Law applicable to trusts and on their recognition, commonly known as the Hague Trust Convention, was adopted on July 1, 1985. It aims to harmonize and provide certainty in the field of trust law, particularly in cases involving international transactions and cross-border disputes. The Hague Trust Convention sets out rules on the law applicable to trusts, the recognition of trusts, and the protection of the rights of beneficiaries. It provides a framework for determining the governing law of trusts and establishes rules for the recognition of trusts in different jurisdictions. Under the Hague Trust Convention, a trust is recognized as a legal institution governed by the law chosen by the settlor. If the settlor has not chosen a governing law, the convention provides default rules to determine the applicable law. This helps to ensure consistency and predictability in the application of trust law across different jurisdictions. The convention also addresses the recognition and enforcement of trusts in countries that are party to the convention. It establishes a mechanism for the recognition of trusts in a jurisdiction where they are not created or administered. This facilitates the cross-border mobility of trusts and provides a level of protection for trust assets and beneficiaries. Additionally, the Hague Trust Convention includes provisions on the protection of rights of third parties dealing with trustees. It aims to strike a balance between the protection of beneficiaries' interests and the legitimate expectations of third parties who may have entered into transactions with trustees in good faith. In conclusion, the Hague Trust Convention is an important international instrument that promotes the harmonization and recognition of trusts in cross-border transactions. It provides legal certainty and protection for trust assets and beneficiaries, while also taking into account the interests of third parties. By adhering to the provisions of this convention, countries can ensure a more efficient and effective resolution of trust-related matters in an international context. The Implement Guide for a Schedule A, Abstract of Administrative Judgment. Introduction. An abstract of administrative judgment is a document that summarizes the key details and outcomes of an administrative judgment. This guide aims to provide a comprehensive framework for drafting an effective and authoritative abstract of administrative judgment. The guide will cover the essential elements, structure, and language style to ensure clarity and accuracy in conveying the information. Title and heading. First, begin the abstract with a title that clearly indicates it is an abstract of an administrative judgment. For example, Abstract of Administrative Judgment, case name number. Second, include a heading that provides additional information such as the name of the administrative agency, the date of the judgment, and any relevant docket or reference numbers. Third, case summary. Fourth, provide a concise summary of the case, including a brief description of the parties involved, the nature of the dispute, and the relevant legal or regulatory framework. Fifth, summarize the main issues, claims, or violations raised in the case, highlighting the key arguments made by the parties. Sixth, mention any significant procedural aspects or hearing processes that may have influenced the judgment. Seventh, judgment details. Eighth, state the final decision or ruling of the administrative body, clearly indicating whether it is a favorable or unfavorable judgment for the parties involved. Ninth, provide a summary of the reasoning or legal analysis behind the judgment, highlighting the key legal principles, precedents, or statutory provisions relied upon by the administrative body. 10th, include any specific remedies, penalties, or orders imposed by the administrative body as part of the judgment. 11th, findings of fact and conclusions of law. 12th, present a concise summary of the factual findings made by the administrative body, highlighting the evidence or testimony relied upon to support these findings. 13th, summarize the key legal conclusions drawn by the administrative body, explaining how they relate to the facts of the case and the applicable legal framework. V. Dissenting opinions or additional opinions. First, if there are any dissenting opinions or additional opinions expressed by members of the administrative body, provide a brief summary of these opinions, including the reasoning and arguments put forth. Second, implications and significance. Third, discuss the potential implications and significance of the judgment, considering its impact on the parties involved, the relevant industry or sector, and the broader legal or regulatory landscape. Fourth, highlight any precedents set by the judgment, noting how it may influence future cases or administrative decisions. Fifth, conclusion. Sixth, conclude the abstract by summarizing the key points discussed in the document, emphasizing the essential aspects of the administrative judgment and its potential implications. The Implement Guide for a Schedule C, Notices of Fault and Demands for Payment. Introduction. Notices of fault and demands for payment are important legal documents used to inform parties of a breach of contractual obligations and to request the fulfillment of payment obligations. This Implement Guide aims to provide a comprehensive framework for drafting effective and authoritative notices of fault and demands for payment. The guide will cover the essential elements, structure, and language style to ensure clarity, professionalism, and adherence to legal standards. Heading and identification. First, begin the notice with a clear and concise heading that states, Notice of Fault and Demand for Payment, party name, case name, contract number. Second, include the date of the notice and a unique reference number for easy identification and tracking. Third, clearly identify the parties involved in the contract, including their full legal names, addresses, and contact information. Fourth, introduction. Fifth, introduce the notice by stating the purpose and context of the document, emphasizing that it is an official notice of fault and demand for payment. Sixth, provide a brief summary of the contractual relationship between the parties, highlighting the specific obligations or terms that have been breached. Seventh, description of the breach. Eighth, clearly and concisely describe the specific breach of contractual obligations committed by the recipient of the notice. Ninth, provide relevant details such as dates, actions, or events that demonstrate the breach and support the claim for fault. 10th, reference the specific contractual provisions that have been violated and explain how the breach has resulted in harm or damages to the notifying party. 11th, demand for payment. 12th, clearly state the amount of money owed as a result of the breach, including any interest, penalties, or other applicable charges. 13th, provide a breakdown of the calculation, specifying the components that make up the total amount owed. 14th, include a clear and unequivocal demand for payment, setting a reasonable deadline for the recipient to fulfill the payment obligation. Consequences of noncompliance. First, explain the potential consequences of noncompliance with the demand for payment, such as initiating legal proceedings, seeking damages, or pursuing other remedies available under the contract or applicable laws. Second, highlight the potential impact on the recipient's reputation, credit rating, or future business opportunities if the breach is not rectified in a timely manner. Third, contact information. Fourth, provide the contact details of the notifying party, including the name, address, telephone number, and email address of the authorized representative or legal counsel responsible for handling the matter. Fifth, encourage the recipient to contact the notifying party promptly to discuss the breach and explore possible resolutions. Sixth, closing. Seventh, conclude the notice with a clear and firm closing statement, reiterating the demand for payment and the consequences of noncompliance. Eighth, sign the notice with the authorized representative's full legal name, position, and contact information. Ninth, consider including a statement that the notice is without prejudice to any other rights or remedies available to the notifying party. The use of RSAI can greatly enhance the operations and efficiency of the Depository Trust Company, DTC, the Depository Trust and AMP, Clearing Corporation, DTCC, and the Fast Automated Securities Transfer, FAST program. RSI, as an advanced arbitration and investment system powered by artificial intelligence, brings a new level of automation, transparency, and trustworthiness to the financial industry. Firstly, RSI's advanced AI capabilities can streamline the processes involved in securities transfers and settlements. By automating tasks and leveraging smart algorithms, RSII can significantly reduce manual errors and operational risks. This improved efficiency translates into faster and more accurate transactions, benefiting both the DTC and the DTCC. Additionally, RSI's integration with the FAST program can enhance the speed and security of securities transfers. The FAST program, which facilitates the transfer of securities between broker-dealers, banks, and other financial institutions, can benefit from RSAI's advanced authentication and verification capabilities. RSI can ensure that securities transfers are executed securely and in compliance with relevant regulations, reducing the risk of fraud or unauthorized transactions.